The Honorable Justices of the Supreme Court. This court from recess now sitting.
Please be seated. Good morning. Ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 10:30 reframe to 11 o'clock docket.
Thank you, Honor. Please, clerk. First case on the 10:30 docket for Wednesday, May 14th, 2025 is appeal number 126819, State of Kansas versus Arredondo Augustine Arredondo, Grant County, briefs both sides.
I think it is. Okay. May it please the court, Peter Meharry for Arredondo Arredondo, present and ready for it.
May it please the court, Assistant Solicitor General Ethan Ziff Sigler on behalf of the Kansas Attorney General's Office, present and ready for argument.
Second case on the docket, number 127139, State of Kansas versus Kamal Matthew Bobian, Riley County, briefs both sides.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Kamal Bobian, and I'm ready for argument.
Good morning. May it please the court, David Loudon, Deputy Riley County Attorney, appearing on behalf of the state of Kansas, present and ready for argument.
Your Honor, that concludes our 10:30 docket.
Thank you, Mr. Shima. Will counsel in 126819, State of Kansas versus Arredondo, please.
May it please the court, Peter Meharry for Arredondo Arredondo. In this case, this comes before the court after my client's conviction for felony murder and an additional charge of child abuse. Those charges arose out of an incident that occurred back in February of 2019. It started with a 911 call my client made seeking medical assistance as the child of his mother was unresponsive. Eventually, the state did charge him with felony murder based upon child abuse, and it's a state theory that he struck his child, causing those injuries and ultimately causing the death. The case went to a bench trial, and we've raised a couple issues on appeal with regard to some of the evidence that district court admitted into evidence and considered in its ruling. Specifically, we've raised issues with regard to evidence obtained during 2 searches of my client's home, and then also evidence obtained through statements of my client that the district court considered in its ruling.
Can we start right at just preservation, or how this gets to us when there's a stipulation that was entered into, joint stipulation at trial for that allowed the admissibility of the evidence you're complaining of? How does that come before us?
There was a stipulation, and it is part of the record on appeal. I think it still is properly preserved. The stipulation, particularly the ones with regard to the statements and the evidence from the seizures, came after, at trial, my client did lodge an objection to the testimony regarding the searches of the house. The district court sustained the ruling that it had already made, but then did grant a continuing objection to the defendant with regard to the admission of that evidence. So we believe that the stipulations, and I think this is in the record as well, weren't to waive any arguments. They were just simply to establish foundation, that there was no objection to foundation, and it was an attempt to streamline the admission of the evidence. Particularly with the searches, the evidence from the searches, the motion to suppress was heard the first day of the bench trial. The district court took evidence, considered it, took arguments from both sides, and made a ruling. During trial, the district court noted when that evidence came in, said, I don't need to see the video again. I just saw it during the motion to suppress. One of the officers that testified during the motion to suppress, they just had the district court take notice of it. So I think the clear intent, I think maybe the wording wasn't what we would always want, but the clear intent was to just streamline the admission of the evidence, not to waive any objection that they already had made. And I believe that's the way the district court took it as well, because it, as I said, it did sustain its ruling in finding the evidence admissible, but did grant a continuing objection to the defense counsel when he asked. So I think it is.
In your position today is that the continuing objection went to this other evidence because the notion is that it only related to the officer's testimony.
I think the continuing objection was related to the motion to suppress and all the evidence that was obtained during those searches of my client's home. The way I read the record was that that was the intent and that was the point of the objection, and that's what the district court granted a continuing objection for. So we believe it is properly before this court. And I would also point out that this was a bench trial. And this court in the past has loosened the standards as far as the contemporaneous objection rule this court has when we're dealing with a bench trial.
So let me just, I understand that, but to get back to Justice Biles' clarification, there was you argue a continuing objection to the, what you call searches, but that then extends to also the statements that were given on different occasions?
I believe the statements is a little different. That is more in line with our argument that because this was a bench trial, because the motion to suppress was actually a state's motion, Jackson v. Deno motion on the statements, that was less than a month before trial. And again, nothing has changed from that point to trial. The same issue, the same arguments. We don't believe an objection is necessary at that point. It's already before the district court. He's already considered it. There's nothing new, and we don't believe that an objection would serve any purpose. The point of the contemporaneous objection is to put it in front of the district court so it can rule on it and make a decision so it does or does not come into trial. This court already did that. And with a bench trial, you don't have that concern. I don't think that this court has noted with jury trials. Frankly, it'd be a waste of time. This was fully litigated. Both these issues were fully litigated before the trial started. The district court made rulings. The evidence didn't change at all. The evidence was the same at trial as it was in these two suppression hearings.
But did the defendant object to the statements during the state's Jackson v. Deno hearing? It seems like that the state moved to admit this evidence. I'm not sure. I don't recall what the position of defendant was. Was there an objection to that admission in response to the state's motion? Well,
The district court had a full evidentiary hearing on it, and then there was arguments from each side as to why these statements should or should not come in. The defense counsel didn't object to the statements coming in during the evidentiary portion because obviously the statements and the surrounding circumstances has to come in for the district court to rule on it. But the defense did argue at the end that these statements should be excluded because defense counsel argued that they were custodial interrogations without the benefit of Miranda. So we believe that's how motions like that work. So the district court had the issue in front of it, ruled on it, and then the trial went forward. So we believe they are properly preserved. And under the circumstances, we believe that evidence should have been ruled inadmissible because the searches, I'll start with the searches. We don't believe that there was a valid consent on the part of my client when the officers went in the second time. There were actually 3 entries. One was in response to the 911 call, which is not contested here on appeal. But then the officers went in a second time, questioned Iraqio, had him kind of do a walkthrough. And then a third time later in the day, different officers did essentially kind of the same thing. But to get in the home, while at the scene, the officers first told Rocky he had to talk to the detective. And then the detective asked, can we go see where? And we don't believe, even though my client went in the house with them, he was...
Are you talking about the second or the third?
I'm talking about the second search, right after
that was right after that was on the same day, correct?
All three searches were on the same day that we're talking about. The second one occurred just after the child was placed in the ambulance and taken to the hospital. The third one was after my client went to the hospital, was interrogated by the officers, and then they came back.
And that second one was just, and he didn't object to this. Let's go in and explain to me what happened here.
Well, I would argue that if a reasonable person in that situation would have felt obligated to go in and explain it to the officers, given the situation. As I said, the officer said, you've got to talk to the detective. And then the detective, starts asking questions. Iraqi starts explaining. Officer says, can we go see where it happens? Points to the house, starts walking to the house. Rocky follows. That is submission to authority. That's not clear, unequivocal consent. It's not freely given. And a reasonable person in that position would feel an obligation to answer the questions and show the officers where everything took place. Similarly, we believe that's a situation with the third search, which was after my client went to the hospital. Kind of the wrinkle with this one is that the police seized my client's home almost immediately.
Well, it's a crime scene, isn't it?
I would argue they had no probable cause to seize the home at that point. All they had was a 911 call asking for help. Somebody was injured. The child was unresponsive. Nothing more. Police arrived. They gathered up the child, put him in the ambulance, and took him to the hospital. The officers at the scene then secured the house at that point.
So help me with facts here. You said you're not objecting to the entry at the 911 call.
Correct.
Did they visibly see there's descriptions of the food having, that made them doubt that there had been, the child had eaten a small piece of the pork chop. Was that visible in that first review?
The first entry, there was body cam, and it basically pans over the apartment as the officer's going in and finding the child. The detail the district court goes into in its ruling, I believe, can only come from the subsequent searches.
Okay.
The initial entry, the officer was probably in there less than.
So they didn't pick up that little piece of evidence for probable cause basis is where I'm.
No, the initial officer that went in, all he did basically was say, where's the child? Went into the bathroom where the child was, gathered the child, and EMS was basically right behind the officer, and they took him out. That officer did nothing as far as investigating the scene. It was only the later searches where the officers went in, talked to Rocky, asked him questions, asked him to kind of do a walkthrough, and that's when they took more detailed pictures, videos, etc. And it's from that evidence, I think, that the district court made it. The district court went into pretty good detail as to, he noted that the pork chop wasn't even cut. It was just bitten off. And you don't get to that detail from the body cam from the first
What
initial
about the
entry.
broken toilet seat? Is that?
I'm sorry?
The broken toilet seat? Was that apparent?
I think it was there in the initial body cam, but I don't know. I'd have to go back and look to see if you can tell if it's broken. But I don't think you can get the detail that district court relied on, except for the evidence obtained from the second and third searches.
In the third search, let me understand, he signed a written consent.
He signed a written consent, but that was, we believe, coerced, and he was pressured into it because of the circumstances. Namely, they had already seized his house. They told him, you're not getting back in. He raised that concern, and they said, well, we can either do this easy way or the hard way. You can consent or we can get a warrant. At all points, when Rocky raised concern, the police just kept pushing, asking questions, and moving forward. Rocky eventually submitted to their authority. That's what it was. It was not free and voluntary consent.
On the second search, do you think that your client was a suspect at that time? Or is there any evidence in the record to show that he was a suspect? The second search was like right after the ambulance left, show me where it happened, what happened. They don't, your position is they don't really know anything yet. You think they thought there was, you're saying it wasn't a crime scene. So was it just investigative at that point?
Your Honor, at that point, they didn't have any indication that I would say points to Rocky as a suspect, points this as a crime scene, and that bleeds over into the why I don't think they could seize the home. But they still went into the home. And they've argued it's consent, and we've argued otherwise. So even though he may not have been a suspect, they still don't just go into his home and say it's investigative. They have to have either a warrant or some exception to the warrant. And we don't believe that they had either of those in this case. They certainly didn't have a warrant, and we don't believe that the consent was valid to allow them to go in. A reasonable person in Rocky's position, given what the officers told him, given what they were doing, would have felt obligated to let him in. But that's not voluntary consent. So even if it was investigative, they still just can't go in willy-nilly and say, we're just going to look around because we're investigating. This is my client's home. He has a right to it. He has a right to privacy in it, and he has a right to keep the officers out. So
Was there any notion that the police would not have been able to get a search warrant?
Yeah, I was gonna ask that.
that was never really raised below. I know the district court, when it was talking about the searches, did note, sometimes he didn't feel the officers were doing anything improper by saying we can go to a judge and try to get a warrant. I don't think the district court weighed in on whether or not it would have given a warrant. It was more, and I don't believe the officers were acting inappropriately, saying they could try to get a warrant. I would argue, as an argument,
There's no argument of deception or anything like that in this deal.
no, not with the second and third entry. I would argue with regard, and this goes to the statements that my client gave at the police station about a couple months after this. He went in, police asked if they could talk to him. He felt that they were just kind of tying up loose threads. That was the impression he got, but that interview became accusatory pretty quick, and he did feel like he was misled into coming in to talk that day. But as far as the searches and what they talked about at the hospital, I don't believe the district court felt there was any deception or anything like that along those lines.
Can I ask you about prejudice here? The statements, it looks to me like were fairly consistent with the testimony the sister gave as well. So I'm wondering if your argument as to why this evidence was prejudicial is more about identity. I don't want to make the argument for you, so you maybe explain to me.
I think this is the statements that came in from my client. They came in through audio and then some of the video when the searches were being done. My client could be heard answering questions. I think those admission of those were a key component in the district court's ruling. The district court made multiple statements that he didn't believe anything my client said. And I don't think you make that credibility determination based upon the secondhand comments of the sister. You make that based upon what you heard directly from my client. And further, I think the statements that my client made were far more expansive. I mean, they were in line with what his sister testified to, but they were more expansive than what she testified to. So I don't think, again, that the district court would have made those credibility determinations that it did without the statements that came directly from my client. For those reasons, we believe the district court did erroneously admit this information, evidence, and consider it in its ruling such that reversal is required. Thank you.
May it please the court, Assistant Solicitor General Ethan Sigler on behalf of the state of Kansas. I think this is a case where I think it's very easy to skip to the end and just ask, is there any chance that the errors they complain about prejudiced the defendant? And the answer is no. I don't believe that there's any question that there is no question that the first entry into the house and the emergency response was valid. I don't really believe that there's much of a question, that there's any question that the second one is valid either. And the third search, which is the only thing where I think there's a legal contention that would have to be resolved, did not get any evidence that was considered by the district court in its ruling. The only evidence discovered during the third search was the replaced toilet seat and the red substances. And of that evidence, the district court explicitly says, for me to speculate on the significance of these suspicious elements on the scene would be futile and certainly inappropriate to take into consideration. So we know that the district court did not consider that evidence in its verdict. So whatever happened with the third search is just harmless because it wasn't considered, and any evidence discovered in the third search was discovered during the second entry into the home and the first entry into the home.
Well, it seems to me that, at least based on the medical evidence, that one might suggest that there is a question as to who the perpetrator of the acts that caused those injuries, the identity. And to that, because the time period of from the medical experts is, not narrowed to 1 hour necessarily. It's before up to maybe 24 hours. And that toilet seat and the other evidence arguably is relevant to the identity of who inflicted injuries.
But we know it didn't factor into the district court's judgment because the district court told us explicitly that I don't consider.
I thought the district court kind of suggested or basically said, I don't believe your version. You're lying, basically, is what he said. And part of that was based upon the change of clothing and the toilet seat. And that was I think that was from the third search, because the first two were fairly contemporaneous with the call and whatever happened.
I think that it's just not, it doesn't make a difference. The principal question is whether the defendant's statement that the child was choking was true or false, and it is clearly not true. There's no evidence that the child was ever choking. There's no evidence that the story he tells about coming out of the bathroom, seeing the child with his hands on his neck and taking him into the bathroom ever happened. And that's evident from the first video. The kitchen table is completely undisturbed and it is visible in the video. So a fact finder has information that is unquestionably admissible that says he is lying, period. And there's nothing else you ever have to get into to consider whether he is telling the truth. We know from the uncontested evidence, the story he told did not happen, period. And from that point on, everything else is just harmless because his lies are evident from admissible evidence. So getting into the second search, I think it is clear that it is consent. If you watch the video, you can see the behavior of Mr. Arredondo. You can see the officers. He's speaking to the officers the entire time. He never breaks conversation. He walks into the house. He's still talking to the officers. He's moving in through the house. He's still talking to the officers. This is fundamentally different from any other case on ambiguous consent where the court continuously points out that the suspect was silent, did not say anything. But I think the reasonable implication of if I am walking into my house and I am speaking, if I am speaking to a person and moving into my house to where they need to follow to hear me, the implication is I'm asking you to come in. And that is a reasonable thing for an officer to believe. So I think that is absolutely consent. Whether he said, yes, please come in, or he's just opening the door for the officers and speaking to them the entire time, it is clear that that is consent. As to the third search, this is where the legal issues, I think, come in. It is clear from the 10th Circuit case, and I'll try to find the citation to that. It is in the brief, that preventing someone from entering their home functions as a seizure. Now, case law in Kansas is ambiguous as to when the seizure occurs. In car stop cases where the defendant is there, the Kansas courts have said that A seizure occurs when a person tries to exert a liberty interest and is denied the ability to exert that interest. But here we have a complicated situation. He's at the hospital. There's no indication that he is trying to go home, trying to exert a liberty interest over his home. It isn't clear that they've actually seized anything at that point. And it's not just at that point what this court has called an attempted seizure. They told him you can't go home, but he has never tried to exert authority over the house. And there are cases, though these involve the seizure of a person, where the court has said until a liberty interest is actually implicated, it is just an attempted seizure and it is not a seizure. The second thing is, there was evidence at that point to give the officers probable cause that a crime had committed. The defendant was alone with an unresponsive child. He had given them a story of what had happened. That story was very evident from the beginning, not true. The things he described did not match the scene in the house, and it was clear at that point that he was lying to the officers. There was an unresponsive child. He was the only one alone with the child. That is probable cause that a crime had been committed. And there are exigent circumstances, because if he returns to the house, he can destroy evidence, change evidence. In fact, turns out that he had destroyed and changed the evidence in the house. So the officers could, at that point, reasonably believe that they had probable cause that a crime had been committed in the house, that exigent circumstances existed to keep him from re-entering the house. And at that point, there is no coercion, because it's not an unlawful seizure. It is a lawful seizure. And a lawful seizure does not create coercion. And the defendant gave consent while he was at the hospital, in a room where he was closer to the door than the two officers. They never displayed weapons. They never gave a sign or showing of authority. So his consent is, if the seizure is valid, then his consent is valid. And that is what the law says. As to the statements, I just don't think this issue was preserved. There is no objection at the trial to the statements. The continuing objection is very clearly just to the search. And I think I am not going to stand up here and say that I don't think they have preserved the searches for review. I think that that was subject to an objection. I think they clearly wanted to challenge that. But the statements, that is not true of. They didn't object to the admission of the statements. They never at any point raised that issue. And while the defense cites two cases where an objection isn't required at a bench trial, it's explicit to bench trials on stipulated facts. And the reasoning that this court has given is because typically the reason we require an ongoing or a contemporaneous objection is because facts change. And you can consider testimony at the trial when you are evaluating whether or not the suppression was valid or invalid. The ability to add new facts or further develop facts is why the contemporaneous objection exists. So in a bench trial on stipulated facts, it doesn't make any sense to require another objection at that time because there's no further facts developed. It's stipulated facts, but that's not what happened here. There was additional testimony, additional development, so it required contemporaneous objections to the statements.
As to voluntariness?
Yes, I think even as to the voluntariness.
Well, was there a Jackson v. Deno hearing?
Yes, there was.
Right, okay.
Right.
Okay, about whether the statements could come in,
Yes,
right? And that has to do with whether it was voluntary, right?
yes,
Okay, so what you're saying is that once there's a Jackson v. Deno hearing and the judge determines that the statements were voluntary, that you have to object at trial. You have to make a contemporaneous objection at trial to voluntariness.
I think so. That's always been my understanding. I'm not trying to mislead the court or any.
But what changed though? Because the state moves to admit the statements. And as I understand it, on the very, like, this all happened like contemporaneously. They have that hearing and then they start the trial and they're admitting the statements. I don't understand why this differs.
Well, the hearing was specifically on the searches, and the defense attorney objects.
Okay, so the Jackson v. Deno didn't happen that same day?
No.
either. I'm sorry.
I believe it happened significantly in advance, because
Okay.
at that point, they hadn't waived a jury trial yet. It was still
Okay.
set for a jury trial, not a bench
That
trial.
was my confusion. Thank you.
Yes, and again, in this case, the first officer gets up to testify to what happened in that house, and the defense attorney says, I object based on what we just argued. Could the court just note my continuing objection? And it's specific to the searches. So the defense attorney clearly knew to do this to preserve this issue. And that's why the state isn't challenging preservation of the search question, because I don't think I could do that in good faith. But I do not believe that the statements were, the suppression of the statement issue is preserved for review by this court. That was subject to ongoing fact development. There was no objection, no ability to further develop the facts. And so at that point, I think that's not preserved for this court's review on the statements.
On the statements, if we do get to the statements, when you watch the interview, particularly the May 14th interview, it's an interview. It starts off, he comes to the police station, they kind of say, what happened here? And it's kind of this give and take about what happened. But midway into it, it does become more accusatory. And nothing, I appreciate nothing prevents asking accusatory questions in an interview, but it certainly kind of transitions into an interrogation. Or would you agree with that? And if it does that require any further action on law enforcement to then apprise them that, yeah, you are a suspect and you have the whole Miranda warnings?
I don't believe so. I think you would have to do more in terms of an exertion of force or some sort of element of making a person not believe that they were free to go. I will just say that under the law, there is no distinction between an interview and an interrogation. All police interviews are considered interrogations. So we already account for that. I think even if it's more accusatory, a little bit more standoffish, if you don't have the officers doing something to prevent him from leaving, we have had many cases in which the interviews were hostile, even, in which they were found to be voluntary. So I don't think this case comes close to that line at any of the points where he was interviewed. I also think the police interviews, the interviews at the police station, I also don't think really develop any substantial facts that aren't already present by his statements to his sister, which are admissible, just plainly admissible. So again, we go back to a lot of this just comes down to harmlessness. Evidence was admissible through other means that are not objectionable or not, and were clearly admissible. And those are that is the evidence the court considered, and the result would not have changed if that evidence had been excluded. I do want to touch on one thing that the defense attorney said, and that is the question of the officer saying, hey, Rocky, you need to talk to the officer, or you need to talk to the detective. He does say that. That is true. But I think within the context of what happened in this case, you can look at the fact that the officer is standing substantially far away from the defendant when this happens. He is torn between working on getting the child into the ambulance and trying to talk to the defendant, and there's no show of force. He doesn't try to stop him from leaving. He doesn't reach for a gun. I don't think that statement in and of itself is enough to overcome the voluntariness of the encounter on its own without any other showing of force or attempt to keep him from leaving. So I just wanted to address that one comment. And if there's nothing else from the court, thank you.
Thank you. You reserve 3 minutes.
Thank you. Couple things with regard to, I think this regards preservation. The timeline is the Jackson v. Deno motion was filed January 16, 2021. The hearing was not held until March 28, 2022. The motion to suppress regarding the searches was filed on April 18th, 2022, and the hearing on that was on April 20th, 2022, which was the start of the bench trial. So the hearing for this, with regard to the statements, was less than a month before the bench trial. And it was a full evidentiary hearing, as I said before, with both sides making arguments to why the statement should or should not be come in. Given that time frame, again, I don't believe that an objection at trial would have done anything other than Mr. Court saying, yeah, what I said earlier. There's really no point to it. It was the same judge. He had heard all the evidence and made a ruling, and they moved forward.
What's your argument that this was a custodial interrogation?
My argument is that
You look at the factors. Go ahead, explain to me what the strength of your argument is.
with regard to the statements, I'll start with the statements Rocky made at the scene right after the ambulance left. As opposing counsel just referred to, police officer told Rocky he had to talk to the detective. And when you're ordered by a police officer, the standard is what a reasonable person would feel they could do, not what a lawyer or
Don't
a
you give that
judge.
some context here? I mean, this is right at the scene. You need to talk to the officer. It was in response to even Rocky wondering what's going on.
When the officer says you need to talk to the officer, that's an order. And a reasonable person, regardless of what they were thinking, would think also they have to do that. They can't go. And if your child was just taken away in an ambulance, you're facing multiple officers, I don't think it's reasonable for us to assume a person would say, okay, he's told me to go talk to the officer. I'm just going to turn around and walk the other way.
Let me tell you.
No reasonable person would believe that.
Okay, if my recollection of the video is a detective pulls up, gets out of the vehicle, officers working on the child at the ambulance, detective asks the officer what's going on, and that's when the officer's like focused on the child and says to the defendant, talk to the officer. Is that, am I misreading?
No, that's the video. I mean, the video is what the video is.
Right.
But I would also point out Rocky was in his house and he came back out after he was told he had to talk to the officer. And that is not voluntary consent. That is submission to authority. He was given an order and he followed it.
Doesn't that make virtually every encounter with law enforcement custodial?
It makes certainly a lot of them because,
Is that
again,
the case law?
I mean, this court has things it considers, it has all these factors, but it boils down to what a reasonable person would feel like they could do.
Yeah, and you're just saying no reasonable person would ever feel like they can avoid talking to police when police say, I want to talk.
I'm not going that broad, but when you look at the circumstances here, you have an officer telling him to talk to another officer, there are multiple officers around. He can't just go and follow the ambulance because he's told to go talk to the officer.
Well, sure he can, right?
No, he can't. You think a reasonable person would not feel they could do that. I mean, eventually he did. And I know one of the factors is whether or not the person was eventually free to leave. But in each instance, he was free to leave after the police were done with him. After they said, okay, you've answered our questions, go to the hospital. But when you're facing multiple officers directed to talk to them, I don't believe a reasonable person would feel they could ignore that. And that's why they're custodial. And that's why Miranda was warranted, as we've argued. One other point I would like to make, the state said there's no evidence to support what my client said, that the child was choking. My client tried both the Heimlich and CPR to no effect. There was evidence of that. Nurse Randolph noted that there was vomit around his mouth. That's record volume 7, page 229. The EMT Fort saw chunks on the child's face. That's record 12, page 116, 117. And then Nurse McNown noticed white and red liquid in his airway when he was at the hospital. That's record 821. So there is evidence that supports what my client was saying to the officers as far as the child choking and that he was unresponsive as a result. For those reasons, we would again ask this court to reverse this matter for a trial. Thank you.
Thank you. Thank you to both counsel for your arguments. The court will take this matter under advisement. I will now call case number 127139, State of Kansas versus Kamal Bobian.
Morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Kamal Bobian. I request 3 minutes for rebuttal, please.
3 minutes, Cran.
Your Honor, I would remind the court that this case is a first-degree murder case, premeditated murder case out of Riley County. My client was convicted of killing his wife, SB. There's a lot not disputed in this case. It's not disputed that my client killed his wife, SB. That's not disputed. My client's state of mind and culpable mental state is hotly disputed in this case, and is the primary subject of the issues raised in this appeal. My intent today is to focus on some of the differences between my colleague and I on issues 2 and 3. The court may have other directions for me, but I'll focus on this. First of all, issue 2 has to do with the refusal of the district court to give lesser included offenses with regard to, in particular, reckless second-degree murder and involuntary manslaughter. The first point I want to raise, again, just looking at the things that my colleague and I disagree with about. In my brief, I argued that one of the things that the district court should have instructed was involuntary manslaughter based on misdemeanor manslaughter. And my colleague has asserted that we didn't raise that, but we were raising it for the first time on appeal. And I would disagree with that. Certainly when you look at record 19, page 869, I think, 859, my attorney in this case, my trial attorney, said we want all the lesser included offenses. We want involuntary manslaughter and cited the pattern instruction without limitation. Now, my colleague is correct that when they had discussion about factual appropriateness, my trial attorney in this case focused on the reckless involuntary manslaughter, but there was nothing in the request that limited that.
Is that our standard for preservation and clear error? Just to say, Judge, I want every instruction that the law requires you to give. Is that enough?
That's what I keep begging all of my trial attorneys to do in response to this court's rulings that under 2234-14, all you have to do is request the instruction and then you've complied with the statute.
You don't have to be specific. You're just saying you can make a general prophylactic request for every instruction that I'm entitled to receive.
The attorney in this case at least said we want every lesser included offense down the chain, including involuntary manslaughter without limitation.
And that's enough. That's your argument.
That's what the statute doesn't say anything different.
Do we have case law that says that? Or would that be a new rule, at least as far as our case law is concerned?
It would be a new rule if you said you have to do more than that. I mean, I'm not aware of anything. The statute says you have to request the instruction. My attorney in this case requested involuntary manslaughter without limitation. Now, the test, when we get to factual appropriateness, then is we're going to look at the whole record. And so, no, I mean, it's certainly our position that was requested, involuntary manslaughter without limitation, and therefore it's treated the same. And by the way, the state agrees that it was factually appropriate. I wanted to shift to the reckless second-degree murder and the reckless involuntary manslaughter that the trial court refused to give, and my colleague agrees was requested. And again, the test here is if the district court had given those instructions, and if my client had been convicted of either reckless second-degree murder or reckless involuntary manslaughter, would this court have reversed based on insufficiency? And I think the answer is clear under Gregory and James in these kind of cases, where my client testified, agreed, or at least there are statements, he didn't testify, statements that he killed his SB, but that he didn't intend to do so, and that the circumstances that would you have affirmed this on a sufficiency analysis if he was convicted of a reckless killing? I think the answer is yes.
Shifting to the harmlessness inquiry, what's your best argument for a reasonable possibility that a jury could find that stabbing someone, whatever, 7 times is a reckless act?
So I just want to be clear, you're specifically using reasonable possibility. So
Yeah, or you can reframe it however you want.
yeah,
I mean, that's what you want, right?
yeah, that's
the standard you want.
I mean, we think we went under any harmless standard
Understand.
here, but so I don't think it really matters that much. So yeah, the testimony in this case is the client says, Mr. Bobian says, I didn't intend to kill anybody. And we can look at a lot of the circumstances, and the jury is required, as this court has often said, to sort of sift through and determine credibility of different situations. One thing you could say is we actually don't have a lot of information about Mr. Bobian's intent, and that's not uncommon. It's hard. It's not always the case where people say, "Here's what I intended to do this day." So you have to get to the circumstances. I think the court, you're sort of saying, had multiple stab wounds, and so that's the situation. Although my client testified that he remembered his wife being stabbed once or twice, but not several times. It's a little bit tied into the first issue. Again, is there a reasonable possibility or probability that a jury could have formed a reasonable doubt that we don't know what his intent was? But whatever the situation was, it was reckless. And so in that situation, the jury, had they been given the option, could have said it was something different.
And maybe that's the best argument you can make, but it strikes me as a stretch to think that a reasonable juror would have a possibility of concluding that 7 stab wounds in which the body is then taken in a van and dumped in a field is reckless.
So one, I would push back on your characterization. The jury doesn't have to find anything. They just have to form a reasonable doubt about whether he had the specific intent. And so in light of the evidence, what evidence did the state have that he had that specific intent? And not a lot, right?
Well, isn't just the evidence I recited pretty strong evidence?
No. I mean, it's circumstantial evidence. I concede that. But is it so strong that no jury could form a reasonable doubt in light of that evidence?
That you just did this on accident because you were reckless?
Or because other circumstances were occurring in the situation that having a knife out and when you're having heated discussions is in and of itself reckless? Okay. Could a jury say, I have a reasonable doubt about whether the state's proven? This isn't a case where you have somebody that said, I'm on my way over to kill my wife ahead of time. That situation, Your Honor, I'd be like, wow, it's going to be hard to get around the evidence of intent. That's not this case at all. It's not this case at all. Could a jury just have said, we don't know what his intent was, what his state of mind was? It seems like he was in a lot of weird places. And if that's the case, could one or more jurors form a reasonable doubt that we don't know what his intent was? If that's true, then the question is, well, that's the answer to the harmless error. That a jury could then, had they been given the option, landed on a reckless offense. Given my time, I won't spend a lot of time on what I think the harmless error test should be on that second issue. We have a disagreement about that. I just would highlight that I understand that the court has said you don't have, for example, that the state constitution and the federal constitution, the right to jury trial doesn't include the right to have lesser included offense instructions. But if your only defense is, I think this was a lesser included offense, it's our argument that that's your defense, just like compulsory. I won't belabor that. I did want to spend some time on the third issue, on the prosecutorial error issue. And the second part of that, where I think my colleague and I have some disagreement. In this case, the prosecutor said, because they did give a lesser for intentional second-degree murder, but the prosecutor said, if you find him guilty of first-degree murder, don't even look at second-degree murder. Don't even look at that. You're done. And our argument today is that's a misstatement of the law, that's not true. And my colleague has cited, and correctly so, that this court has said that, it's rejected previous claims that we have to tell the jury that they have to consider everything contemporaneously. I understand that. But I think maybe the comparison or analogy I would use, it's like, for example, for reasons that escape me, but here it is, that we can't tell the jury that they can nullify. We can't tell them that. Neither the judge can tell them that, attorneys can't tell them that. But we also know that a judge, and I assume a prosecutor, can't tell a jury that they can't nullify. And this court has said that that's the difference. And so the circumstance where this court has said, look, you don't have to direct the jury that they have to consider everything contemporaneously, does not stand for the proposition that they can't ignore lesser included offenses. But that's not correct either. That in fact, in Sims, in response, when this court abandoned the idea that juries should be instructed that they have to consider greater and lesser offenses contemporaneously, said, and we don't really have to worry about the due process implications of this because the jury is told that they still have to consider these things in relation to one another. And if that's the case, then your concern, counsel in Sims, that the jury's not considering these lessers goes away. You're instructed to do that. But the prosecutor's argument in this case runs exactly contrary to that, saying don't compare them. Only look at first-degree murder. If you find that, you're done. And I do think there's a difference. If you're telling somebody, here, I want you to compare these two things, but only look at the one thing. And if you decide something about that one, no, if you are going to compare two things, you have to look at both things. That's what the statute says. That's what the instruction in this case says. That's the instruction that this court relied on to say there's not a due process problem here. But when the prosecutor comes in and says, actually, don't look at both things, only look at this one thing. And if you decide that, don't even look at the other thing, we think that's a misstatement of law and therefore procedural error. Your Honor, that's the completion of my comments.
Any other questions?
Thank you.
Thank you.
Good morning, Chief Justice, Justices. May it please the court, David Loudon, Deputy Riley County Attorney appearing on behalf of the state of Kansas. This morning, I'll focus on what Mr. Hodgkinson has focused on as far as the briefs. I think the issues have been briefed really well. I would largely stand on my brief, but I will answer or rebut some of the things that he said here this morning. With regard to issue 2, our position has been in the brief and continues to be that the defendant did not present any factual basis for a reckless murder instruction, whether that's under second-degree murder or involuntary manslaughter. Whether you believe the defendant's statements to the police after the crime, or whether you believe his testimony at trial. And if you focus on his trial testimony, it's, I was holding a knife, I was going to cut up some clothes. So there's nothing reckless or illegal about that. She comes at me, he reflexively moves the knife, it stabs her, she falls to the floor, and she stabs herself again. Okay, so what we know from that is that would be consistent with his claim that he only remembers, or that he only stabbed her, or there was only 2 stab wounds, 1 or 2 stab wounds, I think is maybe how he said it. But the facts of the case with the showed that there were 7 stabbing or cutting type wounds. So how does that happen?
But isn't that weighing the evidence?
I don't think so, not with respect to determining whether that was actually reckless. And that's why I'm focused on what he had to say. If you take his comments at face value, then he didn't act.
I understand that part of the argument.
Yeah.
I guess I was talking about the number of stab wounds being inconsistent with that theory. But wasn't his position that the reckless component is in the midst of argument, taking out the knife in the first place, than the accident? I understand it's self-serving, but
Right. No,
it's a statement.
I don't think in and of itself, even if that's what he did, in which I don't think that's what he testified to necessarily. But even if that were the case, I don't think that in and of itself is reckless or shows any recklessness at all. If I'm just pulling out a knife and standing there with it, if I'm doing nothing with it, I don't know how that's under our high level of standard for recklessness. I don't know how that reaches that level.
Do you agree the reckless instructions all the way down was preserved in the instruction conference?
For the two reckless ones, for the reckless second and then the reckless involuntary, yes. Those were discussed and refuted and discounted by the judge. With regard to the involuntary on the protective order, I don't agree that that was preserved. I understand his argument being, you know, we asked for everything, and we all know that the judge has a duty to give all lesser included instructions that are preserved by the evidence or supported by the evidence. But at the same time, you know, this is the trial situation is one where the judge will take his lead from the attorneys, and if they're not making an issue out of something, that's probably why it wasn't even discussed. I don't think that was on anybody's radar, and I think it was a fairly new legislative enactment. I don't think that's something that had been around. Now, that doesn't excuse the court from having a duty to raise that. Our position is essentially that he doesn't get to say something in general, not bring it to the court's attention, much like an objection. You have to be specific about it and timely about it. And he wasn't specific about it and wasn't timely. He didn't raise it till now. We submit that the clearly erroneous standard would apply. But make no mistake about it, whether it's clearly erroneous, non-constitutional harmless error, or a constitutional harmless error standard, the state believes that if this is error, and it would be error on the violation of the protective order, because we have conceded that there is no possibility under any of those standards that the outcome of trial would have been different, largely in part due to the verdict in this case, that the jury found the defendant guilty of premeditated first-degree murder. In order to do that, they would have had to find premeditation and the intent to kill, which again, that doesn't foreclose the possibility that they could have found a verdict for the violation of protective order, because there was a killing in the scope of violation of protective order. But there is nothing about our law that says, and this kind of goes to the third issue a little bit, is if the jury finds that if a defendant is guilty of the highest crime charged, even if they find him guilty and go down the verdict and form and find him guilty of that lesser crime too, that crime would be dismissed basically, or that verdict would be disregarded, and the highest crime would be remain in place. So for that reason, we don't believe that there would be any different verdict had that instruction been given on that one. Same reason and so with regard to the reckless ones, however, not only would that apply, but it would also apply the fact that it is not factually appropriate. We don't believe any issue regarding errors on that one. So going to the third issue on that, the state's comments regarding once you find him guilty of first-degree murder, don't move on to the second. It's not error, first of all, because it's exactly what the instructions told the jury to do. I disagree with Mr. Hodgkinson here today, indicating that the jury says, or the jury instructions say, consider all these together. That's not true. The jury was instructed on the primary count of first-degree murder. As to any lesser included offense, very standard language, no surprise to this court, I'm sure. If you can't reach a verdict on the first count, then you can go to this lesser included offense. There's nothing in the instructions that tells the jury that they had to consider everything together before they reach their verdict. This court has agreed with that position, as Mr. Hodgkinson has noted. He's claiming that the statute supports that version, but it doesn't. The statute indicates, if I may here, in essence, what instruction number 7 said is, when there is and I'm paraphrasing, when there's a reasonable doubt as to which of two offenses a defendant is guilty, then you may only convict him on that lesser offense. Well, the predicate is that you have to have two offenses in which you have a reasonable doubt. If they find him guilty of premeditated murder, there is no reasonable doubt and no question about two offenses. So they stop, and that's exactly what the prosecutor asked them to do. So in short, we don't believe that the prosecutor committed any error by following the instructions. In order to find that there is some kind of basis for relief here, you'd have to find that the prosecutor did something outside of the instructions, which the prosecutor did not do. For that reason, I would submit the rest of the issues on the brief.
Okay, before that, would you at least address the claimed prosecutorial errors with respect to multiple, what we've come to call we know statements?
Yes, it is unfortunate that those occur. But I think based on what I've put in my brief and what this court is probably keenly aware of from its precedent is that this court does not just merely look at those words and say, okay, that's an automatic error by saying something. For instance,
well, let's focus on the first claimed error. Prosecutor said, Mr. Bobian intentionally killed SB. We know that happened. Is that error?
No, as indicated in my brief, I think if you look at that in context, that's not a formal opinion. It was something that they use, prosecutor used kind of colloquially.
But haven't we said in our case law, we've been pretty strict about this, that if you use these words, we know, you better be referring to uncontroverted evidence. And if you're not, it's error.
That is true, but as I noted in my brief, there was something even stronger than that, which this court found in King, where the use of the word I believe was not treated in the manner that you're suggesting right now, as far as, okay, this is automatically error. I understand at the end of the day, my entire argument's going to fall back on harmless error at some point in time, because that's probably my strongest argument. But I do think that I don't know that based on this court's law that it is absolutely in every instance based on.
Well, it is interesting that you review a lot of trial transcripts and different prosecutors phrase these different things differently.
Right.
So you have a lot of variation in these little phrases. We've been very specific about the we know phrase. You referenced an I believe phrase, and sometimes we treat those differently. So that leads into my next question, which is, I don't recall a case, there may be some, in which we've evaluated the slightly different phrase, you know. I wanted to get your take on how this court ought to evaluate a you know statement as opposed to a we know statement. And is there any difference?
Oddly enough, I think I might have one in the works of the Court of Appeals on that, but I don't really view it differently. And again, that would fall under the umbrella of.
So you think we ought to apply our we know case law to the you know statements?
I think so, and for this reason, and this is why I started with when this court is faced with one of these situations, you generally look at it in context to determine what was trying to be conveyed. There are some colloquial phrases that people use, and I can't say 100% that's why this occurred in this case, but when prosecutors are up talking or, you know, judges or defense attorneys for that matter, they say things that are comfortable, even though we caution against using those comfortable phrases.
Well, I think that the rationale that this court has given for treating we know statements with a strictly, let's just say, is because it's that royal we brings in all the authority of the state to bear in a vouching kind of a way. Is the same true of a you know statement?
When you state it that way, no. And, you know, I just want to push back a little bit. I know that, you know, it's one of those situations. If, you know, you have dealt with this a lot over the years, and it gets to the point of, you know, how many times you have to say this before people start figuring this out and not making this mistake.
What's the answer to that?
I wish I knew. I wish I knew.
It does get, I mean, this is a continuous, at least once a docket kind of thing.
It definitely is. And as I tell people in my office, you know, it's like that one slip up by you cost me hours of work. Okay. It costs everybody hours of work. And I think that's why in part in my brief, I also say, you know, when you step back and look at this, I mean, obviously back in, you know, I'd say, let's just say late 90s, there was a lot of this stuff going on, even far worse, you know, calling people names and doing that. This court put a stop to that and said, okay, we're not doing that anymore. And I understand that this court has to have, you know, for lack of a better term, a bright line rule regarding some of the language that's used, because when we look at things objectively, we say, okay, how do we tell if something is an opinion? The easiest way to tell something is an opinion is by the terms we, I. Okay, those are easy targets. But, you know, the court has looked at it as well and said, look, okay, that doesn't necessarily mean they're giving an opinion. And if you look at it objectively in this scale too, isn't the entire closing argument the view or the opinion of the prosecutor in its case? I think everybody understands that it probably is on some level. So then it begs the question, if they slip up and say this other thing, what are they really saying? Are they trying to say something in context? And if the answer is, look, we're just going to call it error, and then the rest of it, we're going to submit to harmless error, maybe that's maybe the bulk of my argument. And that's why I say maybe it falls back on that eventually. Because ultimately, I think everybody understands, especially from the jury instructions, what the jury is constantly told through instructions, follow the instructions. The instructions say that the prosecutor's statements are not evidence, are not to be disregarded, or to be disregarded if they aren't supported by the evidence. And, you know, as I point out in my brief, if we substitute I submit into that, it appears that we're not having the same conversation, because this court has said I submit is okay. So what is the real difference between I submit, we know, I believe? I mean, what is the real difference? I don't know. And that's why I'm taking the position I've taken on this thing. And I just ask this court to maybe look at that aspect of it. Ultimately, in this case, I think it's, I see my time is out. It is going to come down to harmless error, regardless of what this court says. But a rule that fashions something in this manner, even though you've said it once before or twice before, might be helpful. I don't know how you're going to say that to make it worthwhile. Anyway, I ask this court to confirm or affirm the convictions in this case and affirm the district court. Thank you.
Your Honor, I have just a couple points. First of all, with regard to the factual appropriateness for reckless second degree murder or reckless involuntary manslaughter, I also just wanted to point out that under Kansas law, under statute, if there's evidence of intentional conduct, there's evidence of reckless conduct. And so under Kansas statute 215202, to the extent that there's evidence of intent, and I haven't said there's no evidence of intent, there's evidence of recklessness. And so this court
What
would.
is the reckless conduct? Is it taking the knife out? What was the reckless?
It could be that, but for the statutory argument I'm talking about, it's the Kansas legislature said,
No, I know.
okay,
I've changed the subject.
okay.
All
No,
right.
I'm saying it's a matter of law, that's it. But
Right.
in this case, it could be that. I mean, again, and in fact, I don't know that we have to show it. It's just, he said, I admitted that I mean, that the very base of it is, I admit that she was stabbed, that I stabbed her, or at least that she was stabbed. But I didn't intend to do that. And so is stabbing somebody, even if you don't intend to do something, is that at least reckless?
But
Yes,
what evidence supports that besides him saying that? Or is that enough?
that's enough. That's enough for recklessness. When you look at things like James and Gregory, right? That somebody can do an intentional act, but not have the accompanying intent.
I know.
I can stab somebody, but not intend to kill them. But it's almost certainly reckless to do so, right? So that's the base, at the very, very base of it. I mean, we can get into the, is it reckless to get a knife out when you're having a heated argument with somebody, or to have a knife in my hand and move it when somebody's coming at me? That might be evidence of recklessness too. I think it is. But I don't even know if you have to get that far. You could just say, he admitted that she was stabbed, but he didn't have the intent to kill. Under James and Gregory, is it still reckless though? Would that be evidence of recklessness? And I think the answer is yes. The last point I wanted to make, and I wanted to point out as I was reviewing this case that part of the state's response to, if you find it error to not give the reckless second-degree murder, is that there was a second-degree intentional murder instruction given in this case, and the jury did. But I find it a little bit difficult to understand where the prosecutor said, explicitly told the jury, don't consider second-degree murder, but then argued at this court that it's harmless because the jury didn't find second-degree murder.
Wasn't that in the context of basically an order of consideration? The prosecutor said, the state's argued that the prosecutor's argument was consistent with the instructions. Consider the first charge, consider the primary charge. If you can't reach a verdict, consider the lessers. And why is that wrong?
Yeah. So, and this is based on Sims. I mean, when we argue, or when defense attorneys argued that, look, that's impeding, that instruction impedes whether the jury actually considers lessers, this court said, no, it doesn't, because we give the jury an instruction that also says, if you have a reasonable doubt between the two things, then you have to go with the lesser. And that shows, that evidences that the jury's still considering all of that.
Did they get that instruction here?
They did get that instruction here. But then the prosecutor said, don't follow that instruction.
Well,
only follow this one instruction.
Is that really what the prosecutor said, if you find him guilty of premeditated, then you stop?
That he said, don't look at second-degree murder.
How's that different than you stop?
That's contrary to the instruction that says, if there's a reasonable doubt between two things, you have to go with the lesser.
Before a decision is made, is it not?
I'm sorry?
I don't mean to be argumentative. I'm just trying to drill down to.
Yeah.
Is there a difference between what you're arguing, which is prior to reaching a decision, you should consider all of them and weigh them against each other, versus once you have reached a decision, you need not do anything further?
Can you restate that, Your Honor?
Well, maybe. We're sort of parsing out a very fine line here.
Yeah.
Between before you reach a decision, before you reach a verdict, you need to weigh all of the primary charge and the lessers. Versus once you have reached a verdict, you don't need to do anything else.
And the prosecutor said, in this case, explicitly said, don't even consider second-degree murder.
Wasn't it after you've reached a verdict? Wasn't that the context of the statement?
But it's still, don't consider second-degree
murder. So you don't think there's any difference between those?
My concern here, and when we see this argument coming up sometimes by prosecutors, is I don't think Sims or any of the cases cited in Sims is for the proposition that the jury still doesn't have to consider lessers when it's making that determination of whether
even after it's reached a verdict.
I think it's your turn. I think you're putting the cart before the horse. You can't reach a verdict until you've considered the lesser.
Okay.
That's the problem here. But the prosecutor in this case said, don't even consider the lesser. If you've reached a verdict, you don't even need to consider it. And I don't think that's consistent with Sims. That's why I think the argument is improper. I've used my time and more, Your Honor. Thank you.
Thank you. Thank you to both counsel. We will take this matter under advisement. The court is